Welcome to Sakshi TV special immigration talk show with attorney Mr. Parvathaneni. Please note that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Kaveti, on Wednesdays with Prashanti Reddy in English, on Thursdays with Parvathaneni, and on Fridays with Banu Nidra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, you can definitely log on to the firm, which is www.h1blawfirm.com site. It provides you with the latest and cutting-edge information about U.S. policies and terms, explained in terms which do not have to be a lawyer to understand. So without any further delay, let's get on to the topic. You can also call us to the numbers on the screen if you have any questions related to today's topic. So without any further delay, let's welcome Mr. Parvathaneni on our show. Mr. Parvathaneni, welcome back. I hope you're doing well.
Hello, Shivani, and thank you all for watching Sakshi TV and joining us today for this show.
Yes. So, Mr. Parvathaneni, today we thought we will be discussing a little about the 2024 CAP filings and also, about the second lottery that might happen. So, before we get onto it, can we know about some latest immigration updates this week?
Sure. So, the August visa bulletin just actually showed up. It just showed up this morning, July 13th. And the visa bulletin is not very, it's not something all of us have been expecting. It's gloomy. There is no movement whatsoever in any of the categories for Indian nationals. And the EB1 category actually retrogressed back. So EB2 and EB3. EB2 is stuck in 2011. EB3 is stuck in 2009. And at least they're forecasting, it doesn't look too positive in the next couple of months. However, starting October bulletin, we might see a little bit of movement, at least back to where it was a couple of months back. So hopefully, I think once the October bulletin is back, we more than likely will see things move to 2012, hopefully. But at this point of time, we have to wait and watch and see how the family-based visas are getting allocated, being used, because we still have time. So we have until September 30th for all the family-based visas to be used. So the October bulletin more than likely will have better data, better statistics. So hopefully we do anticipate movement in October, and before October, more than likely might not see much forward movement in the visa bulletin. And also in terms of recent updates, there was also an updated guidance recently by USCIS for EAD card. So it is employment authorization document, and it's for some kind of unexpected circumstances. So typically, if somebody's on H1B, they lose a job because of medical reasons, or they lose their job because of a dispute with their employer, and there is some retaliation. So in those kind of extraordinary circumstances, USCIS is now saying that they will let people utilize an EAD card because maybe they need some time off for medical reasons, or maybe they have to go to another place and work because of medical reasons, they have to relocate and so on. So this is a good update from USCIS. They came out with the guidance and they explained who qualifies and how it needs to be done. It does not provide any status, but it lets them stay back in the country if they qualify. So people who are losing jobs and feel that they have some extraordinary circumstances, maybe they have a family here, they have a house, they're losing job, they're not finding a job within 60 days. This EAD card is one of the things that they can explore. And for the final update, so June 30th. So the June 30th is when USCIS will stop accepting cases, the H1B CAP cases, and that just passed. So pretty much all the employers, whoever wanted to do the H1B filings, the CAP filings, they've all completed their filings in June. So as of June 30th, USCIS has stopped taking cases that were selected in the lottery. And if somebody got selected in the lottery and they did not apply, USCIS will not accept any of those cases. And even if the company tries to file them, they will reject them. So basically, the window closed. And right now, all the cases that were applied in the month of June, we are seeing receipts, and some cases are seeing very quick approvals, even if they're done in regular processing. And for the next couple of months, we will see more adjudications as USCIS clears up all those petitions that were filed for the October cap.
Yes. So, Mr. Parvathaneni, you just said that that June 30th was actually the deadline. But does that mean that people cannot file for the H1Bs again? And can you explain in detail about this whole mischief?
Sure. So the lottery was done in the month of March, and starting April 1st, one can apply for the H1B if they're selected in the lottery. So USCIS is technically giving everybody, whoever is selected in the lottery, 90 days. So the companies have 90 days to get their petitions out. So the actual petition with the petition filing fee, all the supporting documents, all of these have to be mailed out to USCIS in a proper fashion. And 90 days is good enough time. So USCIS basically says that as long as somebody properly files a petition within this period, properly pay the fees, they will receive and work on those cases. And what June 30th means is if somebody failed to do so, and definitely a lot of people might not have filed. A lot of companies, they did not file for various reasons. And from a USCIS perspective, they will close out the initial selections. They will look at how many people have applied. They will look at how many people have not applied. And they will not let any further petitions for whoever got selected in the March lottery. They might do a second lottery. If they do a second lottery, they will have a chance. The people who get selected next will have a chance. But whoever were already selected, so in the month of March, they said these people got selected in the lottery. Those people, if they have not filed, that's it. It's done, and they will not be able to file anymore for this fiscal year.
Yes. And also, Mr. Parvathaneni, what do you think about the second lottery? What are the chances for the second lottery? And you yourself are an attorney. What do you think are the chances this year?
So again, so this lottery is a pretty recent thing. So we just have it for the last couple of years. Last year, they did not do a second lottery. They only had a single lottery. But the year before that, they had three different selections. So 3 different times they basically declared those lottery results. And the year prior to that, which was the first year, they had the lottery twice. So they have done it in 2 steps. This year, more than likely, we will have a second lottery. We did not have it last year, but more than likely, at least from the facts that I'm seeing, from the data that I have, and from the filings that we have done in our law firm, I do think that a second lottery is a very good possibility this year. And the reason being, USCIS, in terms of the number of selections. So last year, they selected 126,000 selections for 85,000 slots. Because USCIS, what they do is, they select a few more than what they anticipate, because they know a couple of folks will not file. So based on that anticipation, they actually select a couple of numbers more than what are actually available. And then, so compared to last year, this year, they have selected less number of people. So this year, as per their statistics, only 110,000 have been issued selection notices. So there's already a decrease in number of selections. And then USCIS came out with notification about multiple registrations. So they notified and they let everybody know that they suspect a lot of fraud in the H1B registrations. And the reason for that, they said they received a huge number of applications and a majority of them were duplicates. Basically, when they say duplicates, what they are saying is for the same beneficiary, multiple companies have filed. And the number is so large where they suspect that there is collusion between different companies to increase somebody's chances in the lottery. So they came out with this announcement and they said, because we feel that there is so much of misuse, we're going to refer them for criminal prosecution. We're going to refer the people that we suspect have committed this kind of fraud to the appropriate agencies. And ever since that notification came out, at least what I've seen is people did take it seriously. And it looks like a lot of people, because clearly there was a lot of fraud. Otherwise, you'll not see those number of applications, those number of H1B registrations. But at least the good thing is, at least reacting to USCIS's notification, a lot of people have stopped the filings. And we have recommended this pretty much to every company that we work with. And we said any kind of either direct or indirect collusion to increase somebody's chances in the lottery, people should not be filing. And it looks like people did, a lot of companies, they did look at this announcement, USCIS's announcement from April, and a lot of companies did not file. Even if they had a little bit of collusion, people stopped. And what that means is it looks like a lot of people, a lot of companies did not file. And at least from the data that I've seen a lot of companies not decide not to file because they apparently felt they had some issues. And what that means is June 30th is over. Now USCIS exactly has the numbers. They know how many people have applied. They're going to run their data analysis. They're going to do their statistics. And it will be easy for them to figure out how many people have not applied and how many slots are open. There are 85,000 slots that are available. And more than likely, a lot of slots are not filled out because of this multiple registration issue and because of USCIS's warning. A lot of people took a step back. And what that means is many of the slots will remain unfilled because not many people have applied. Once USCIS finishes their data check, I do expect them to release the numbers. And if there are any slots open, they will definitely utilize second selection and let people apply for the second time. So we do hope, and I do think that we might see a second selection announcement anytime now, either this month or early next month.
Yes. So Parvathaneni, a couple of weeks ago, we did have a conversation about this fraud, multiple registrations that have been happening. So are there any latest new updates about these, especially about, how people are getting trouble with the multiple fraud registrations that have been happening?
Yeah. So USCIS clearly has been looking at this issue very, very keenly. And from a USCIS perspective, what they're doing is they are sending out notices, at least for the cases that have been filed last year. So all the 2023 cap, which were filed last June. So they have been issuing notices. And these notices are coming since last October. We started seeing these kind of notices for companies who engaged in this kind of collusion, at least since last October. And in the last month or so, we have seen a lot more of those cases where there are clear issues, those cases getting revoked. So in the last couple of weeks, what we are seeing is this revocation notices, even for cases that have been approved last year, because there is multiple registration collusion and the company did not provide evidence. What we are seeing is revocation of those notices. And along with those revocation notices, we are also seeing a statement that says this employee is not eligible for cap exemption anymore, and they have to go through, and their visa number is being put back into the system. So what that means is if anybody who has got an approval last year and the company got a notice of intent to revoke or notice of intent to deny, the case is not yet approved, after the revocation notice, so in the last few weeks, we have been seeing these revocation notices being sent by USCIS. If the case is revoked due to this misrepresentation or fraud, what it means from an employee perspective is they're not eligible for cap exemption anymore. They have to go through the lottery once again. So what that means is they cannot just do a transfer and go to another company. They have to wait until next lottery. They have to re-enter the lottery. And if they're selected in the lottery and there is no multiple registration fraud, this collusion issue, they will be able to get back into H1B again. But they have to go through the lottery process again. They cannot use their old approval. Because of this revocation notice, the visa number has been put back and they will not be able to use it. And on top of it, for the recent cases, so the 2024 cap, so for the lottery that just happened in the month of March. So for those cases, we are not seeing any notices yet. However, it does not mean anything. Even though we are not seeing any notices, USCIS, because they need some time. They need some time to analyze all the data. So just because somebody did not get any notice yet for the 2024 cap does not mean anything. If somebody has committed fraud, USCIS has the data. They'll be able to figure out patterns. Seeing the data patterns, they'll be able to figure out if some companies colluded. There are a lot of overlapping registrations. What that means is two companies filed for the same set of people, too many overlapping registrations. So these are the kind of data patterns that USCIS will be able to figure out because they have very, very, very good computer tools that they use, and they will be able to analyze these kind of data patterns. So for people who have committed collusion and filed a lot of cases in tandem with other companies, they might expect to see notices down the line. But at least the notices that we're currently getting, it's more for 2023 cap, but not really for the most recent lottery.
Yes. And let's also talk about ways how these highly educated, people who have studied in USA can, stay back apart from the H1B. Is like the H1B the only way people can stay in the country, or are there any other ways, Mr. Parvathaneni?
So if somebody wants to legally work in United States, so there H1B is like the most popular option with Indians, but there are a lot more options. And in general, there is an L visa, there is a P visa, O visa, which I'll briefly describe in a minute. These are available for Indian nationals too. And for somebody who does not carry the Indian passport, for somebody that has a different nationality, there are other options. There is a TN visa, there is an E3 option for Australian citizens, and there is E1, E2 for the countries that have a treaty. So for India, we cannot use TN or E3 or even E2. But in general, we can use L1. A lot of Indians use L1 option to work in the United States. A lot of people also use P option and O option. So O visa. So O visa is a very good visa. It is for people of extraordinary ability, but it's a non-immigrant visa. So a non-immigrant visa is like a temporary visa, just like a H1B. So I'm seeing a lot of people who are doing startups or creating startups who have good ideas. They are actually going for O visa. So O visa is a very good option if somebody has some extraordinary ability. And extraordinary ability does not mean somebody is getting a Nobel Prize. Even something very good, some kind of a good startup with a good idea, they might qualify for a O visa. So I think people should start looking at O visa. For somebody who is well qualified for H1B, because O visa is a good option. But however, the burden is very high. But a lot of people do qualify for O visa. And L1 visa is a good option. A lot of Indians do use it. However, the only problem is they have to work in India for 1 year, and they have to transfer to the same company or their subsidiary's office in US. So there is this 1 year requirement to work in India. But if they do, for example, companies like TCS, companies like Infosys, Cognizant, they have offices in India, and somebody's working in their India office. So a lot of times these companies use L1 visa to send those employees to US. So L1 visa is a good option. And if somebody does not get selected in the lottery, a lot of companies do use L1. And for the students who don't get selected in the lottery, if they have OPT or CPT, those are another valid and legal ways in which somebody can work and contribute to the US workforce. So a lot of people do work on OPT and CPT status. And so these are typically some of the ways that people can work in the United States if they're not selected in H1B lottery.
Yes. And also, Mr. Parvathaneni, we're hearing bars and bans for people during the time of during the court or the visa interviews. So why do you think can be the reasons for this, the inaccessibility to the country? Are there any specific reasons behind it? And what is your take on this?
So sometimes people get stopped at the port of entry even if they have a visa, and sometimes people get stopped at the visa interview. So a lot of times people think that the minute you get a visa, it is guaranteed entry into the United States. However, just getting a visa is not a guarantee that they will be admitted into the country. So there is another process. So there is another step. So somebody gets a visa. So the first step is obviously getting the visa. And during the visa interview, there is a lot of questions that are asked, and they have to clear that. So once they clear the visa process, the next step is port of entry. So the port of entry is basically somebody comes on the flight, they come on the airplane, they land in the United States. And once they land, before they clear the customs, they have to finish an interview with a CBP officer, Customs and Border Protection Officer. So they have to clear that interview. Sometimes it's very, very short. Sometimes it takes a few, if there is a secondary check, it could take a couple of hours. But in general, for most people, it is a very short, probably a 5-10 minute interview max. So they have to clear that interview. And what that interview is once they get out of the flight, they have to convince the CBP officer at the port of entry, at the airport, that their intention is to maintain status and follow the law. So the CBP officer, they typically ask questions to ensure that whoever is entering the country, they're going to follow the requirements of their visa. If somebody is a student, they're supposed to study. If somebody is on H1B visa, they're only supposed to work for that company. They can only work in that role. They cannot work as an Uber driver, for example. So there are certain limitations on each visa class. So the CBP officer at the port of entry, they are trying to make sure somebody is going to work or do whatever they're supposed to do as per their visa requirement. And what sometimes happens is, if the CBP officers, they're good at catching fraud. And sometimes if they suspect fraud, they do what is called a secondary inspection. So they pull them out of the queue and they have a secondary inspection. So another officer comes and does another extensive interview. And very rarely, we do see situations where they catch something that is detrimental to the employee, either through his statements or either by looking. Sometimes they take their phones, their laptops, and they can look at their phone messages, and so on. So sometimes when they find some detrimental information, or if they find the employee is lying to them, that's a big thing. So employee can never ever lie to a US government officer, and if they catch them in a lie, they get a bar for willful misrepresentation. So sometimes what happens is people are stupid enough to lie to the US government officers, and they get caught. And once they get caught, we do see people getting deported. They're getting sent back from the port. So they get put back in the airplane, the next flight, and they get sent back to India. It is rare, but it does happen time to time. And what that means is everybody should be aware of what happens at the CBP interview, and they should understand that they are supposed to follow the rules and tell only the truth, make only truthful statements to the CBP officers. So it is not. So these kind of things, these kind of bans and bars don't happen quite often at the airport, at the CBP port of entry inspection. However, they do happen. And what that means is everybody should be aware of that extra step and make sure they intend to completely follow the requirements of their visa.
Yes. And also, let's talk about waivers for, the non-immigrants of the country. So what kind of waivers can, the people use in USA, especially during, when they're having this inaccessibility issues and stuff like that?
So some people are inadmissible to USA. So inadmissible means they cannot be given permission to enter the United States for a variety of reasons. So there are a variety of reasons why somebody is inadmissible. So the most common reason is willful misrepresentations or committing some kind of a fraud. So if somebody commits some kind of fraud or misrepresents, so when we talk about misrepresentation, what we mean is they are giving some information to US government officers, which is false, and they're willfully giving that information to get some benefit. So maybe they're producing some fake educational documents. Maybe they're producing some fake experience letters. So in any kind of willful misrepresentation. So that if they get caught, there is a permanent bar. So that is one reason why somebody would be inadmissible. Another common reason is some kind of a criminal record. So if somebody has a criminal record, typically crimes of moral turpitude, so if they have committed some kind of a crime, assault, battery, or some kinds of a crime, they could have a bar. They're inadmissible. Sometimes it's also other issues like domestic violence, prostitution, doing drugs, and so on. So whenever they have these kind of criminal record, they are inadmissible to US. And sometimes it's also health reasons. Sometimes somebody has some contagious disease. Sometimes due to health reasons also, somebody might have be inadmissible. And until they take a required vaccination, they're probably not allowed into the country. So when somebody is inadmissible, what they're supposed to do is they are required to ask for a waiver. They're supposed to apply for a waiver. And only if they get a waiver, that inadmissibility is removed and they're allowed to enter US. So what that typically means is, if say somebody is committed some criminal offense, they have to at the time of the visa interview, they are supposed to typically properly document the issue, request a waiver. If they have misrepresented and committed some fraud, they're supposed to again request a waiver. So if somebody is inadmissible, it is not easy to come to US, but there is a process. There is a process where they can request a waiver, and the consulate, they also have a process. Once they get a request for a waiver, they're supposed to review it, and again it is supposed to be sent back to CBP. So there's a process where somebody has to follow. So what we recommend is, typically one should try not to do anything that will make them inadmissible. But if they're inadmissible, and if they want to come to US, follow the proper procedure to request a waiver. And this waiver is to waive the inadmissibility and make them admissible once again.
Yes. Finally, Mr. Parvathaneni, we only have like 1 or 2 minutes. Is there anything that you want to say to the viewers?
Sure. So, because when people are dealing with H1Bs or visa interviews or with CBP, they're dealing with the US government, and they're also keeping their career on the line. And what that means is, because everybody wants to work hard and improve their career, the main suggestion is one has to be very, very careful when they are submitting any kind of documents. Make sure all the facts are accurate, and even accidentally don't misrepresent any facts. Always be honest with the interviews, always be honest with the CBP Code of Interviews, and any kind of documentation they submit to USCIS. Because the main issue that we see is, if there's any kind of misrepresentation, any kind of fraud, it completely jeopardizes their career. If it is just any other kind of an issue, typically USCIS will always make an exception. It is only when there is misrepresentation, fraud, that's when things become extremely difficult. So an advice to all is always be open and honest at the visa interviews, always open and honest at the CBP Code of Interviews, and always make sure you're using only the right documents for your filings.
Yes. Thank you again, Mr. Parvathaneni, for tuning in. I had such an amazing time as usual. I'm sure the viewers had a great time too. Thank you again for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you.